Well, I don't know that you're left with that. I think that you have a floodplain manager that you could approach. Have you ever approached Mr. Wellings about that?
Well, I actually did talk to him about it not too long ago, but he didn't really discuss it. He was just surprised to hear that it happened. Would I be able to come, would this, in his power, would he be able to say, hey, you can't have that thing there?
I would suggest that he's your local authority to suggest, and he could suggest some help to you. And maybe he tells you to call the DEP, but at least you have someone here who's a certified land surveyor and a certified floodplain manager. It's not like you don't have someone here in Doddridge County.
So this would be part of his job to be to protect me by going to him and saying, I have this problem, can you handle it?
Well, I think he's available as the floodplain manager to hear you.
You can complain, don't you?
Yeah, right.
Can I say something to that? Typical death of Dan Willis. He started 6 months ago. He came to a class right after he got in, so he's eager to learn. He learned, he caught on quick where he's a surveyor. I mean, he's doing well. Something like that, go to Dan, call my office, and I'm gonna call Dan and say, hey Dan, what about this tank? Seems to be washing off its foundation a lot. Did you call it EQT? Don't strap that thing down.
Don't strap
Strap it
down.
down. Needs to be strapped down. Yes, ma'am.
Well, I mean, common sense would tell you if you're going to build in a floodplain to lift it in the air. But reasoning would tell you you shouldn't build there to begin with, let alone have something as dangerous as that just floating along that could hurt a lot of people.
And that's why you gotta strap them down.
We got mountains,
You gotta hang them.
why can't they put them up higher? Why? Yeah, I realize it's easier to get to the floodplains. But, I mean, where is the protection in these ordinances?
Well, it is in the ordinance
Yeah,
for things like that could be washed down the creek and come up.
But you gotta wait till it washes down and
You're called in
hurts it?
section 6.1 of the ordinance that you're required, it's in the floodplain now, it's required to be strapped down, anchored, and what's the other
Elevated.
word? Elevated.
Why?
Or reinforced pier.
So your floodplain manager could do something about it.
He usually sends a letter out, sends a second letter out, and once he deems it's a violation, there's a violation, $50 for now, $5,000 a day, which I like. I mean, these violations, $50 to $5,000 a day. If he calls and finally makes contact with them, and the county commission backs him up and says, you need to anchor this. You need to get this thing anchored to the ground, and they refuse to do that after that, they could be fined. And it could get pretty heavy.
But you're the insurance
Yeah,
man,
they
right?
got plenty of money.
You're the insurance man, you're not the DEP or the
Nope.
DNR.
Oh, sorry. He was first, I'm sorry. Go
My
ahead.
general comment, introduce myself first. My name is David McMahon. I am a lawyer. I'm a co-founder of the West Virginia Surface Owners Rights Organization. And I want to tell you, I really like the fact, if DEP does have jurisdiction over that, I was just trying to move things along. More than anybody knows how weak their enforcement actions are.
Yeah.
I can't tell you the number of stories. Yeah, we called them and they called the driller first, so by the time we got there, they'd taken care of it, right? Or they hadn't taken care of it. So, but I appreciate that I can now tell the story when people ask about enforcement. And I can say I spoke to a group in Doddridge County that laughed about the lack of enforcement. Let me finish, please. First, I want to thank the county commission. You guys, they said that Marcellus was a game changer. It just didn't change today's game. It didn't change the season. It changed the way these games are played. And you guys are right in the middle of it. And I want to thank you because I know you're working hard trying to do the right thing. It's not always easy to know what the right thing is. But as he said, you need to have a floodplain ordinance so people can get flood insurance. And even if you don't have flood insurance, you need to have a floodplain ordinance so if you do have a disaster, FEMA can come in and help. And I know this not personally, but one of my best friends was in a flood in Kanawha County. And I don't know that they had flood insurance, but they had FEMA come in and I don't know where they'd be without FEMA coming in and helping out. You guys probably know about that. And of course, the third reason to have a floodplain ordinance is to keep you from getting flooded by your neighbor and doing those kinds of things. So it's good stuff. I should also say, not only my co-founder of Surface Owners Rights Organization, and I represented the Huffs in the original EQT suit. I originally represented the house in the EQT suit. Eventually, I was out of it. I'm the one that filed the motion that the judge granted that said it's unconstitutional. And I'm going to comment in a little bit. My biggest comment is going to be about, I think that if the floodplain coordinator makes a decision and there's an appeal in there to the county commission, my concern is that how the county commission decision can be appealed to circuit court and beyond. Because I think that a lot of you people you're not going to, if you have a hearing in front of the county commission, you're not going to hire a lawyer. It's pretty expensive to come in and do that. And if you have a hearing in front of the county commission and you get decided against, I think you need to be able to go to circuit court and start over, not just have your entire decision, your entire case decided on what you knew to present in front of the commission. So I think we need to have an appeal process that definitely does allow appeal to the circuit court by either side, and that lets it start anew. Use what, of course, has happened, but start anew. That's going to be my biggest pitch. And I especially thank the county commission for putting notice to other people in here. That's one of the things you were particularly concerned about. Now, when someone goes to do something in the floodplain, there'll be at least a notice in the paper, no matter how far away you are. There will be adjacent, the surface owner, if they don't own the minerals, is going to notify, which didn't happen to the house when they moved 19,000, proposed moving 19,000 cubic yards of dirt into their meadow, and to at least some neighbors. So I thank the county commission for doing that. I assume that part is going to pass. And those are the end of my general comments. I will want to speak more when it comes to the appeal.
Thank you. Anybody else have a comment?
I just had one general comment, and I know we've got a lot of lawyers in the room, so you get into semantics, but my understanding is that the county's floodplain ordinance was not declared unconstitutional by the judge. The judge merely stated that there were sections within the ordinance that were insufficient in protecting the constitutional rights of the property owners. There's a difference there. We do have a floodplain ordinance, and it is in effect, and it is working. It's not as good as it could be, and that was what the judge was saying. We needed to do more to protect property rights, and that's what we're here to tweak. I'm assuming that's my understanding of what the judge stated. Because we do have an ordinance and it is working. It has not been thrown out, correct? We do have an ordinance in place. We're just tweaking it now.
Well, that's a legal dispute. The judge clearly held the ordinance unconstitutional on the failure of notice under due process type grounds. There are parts of Judge Sweeney's order that appear to say that the remainder of the ordinance is still alive and well.
Okay.
There is a severability clause in what I'll call the current ordinance, as there is in the new proposed fourth draft that could sever a portion of the ordinance if it's held unconstitutional, like Judge Sweeney ruled. It is correct that Judge Sweeney, while he can't direct us to do anything, being the county commission, he obviously suggested that there's a constitutional problem with the lack of notice, so that should be rectified to put into effect an ordinance that is constitutionally valid, because the county commission should be in the business of passing constitutional provisions in ordinances. However, I will say that we're going through this process to, you say tweak it, which we are tweaking it, with all due respect to Kevin Sneed and the state, because they didn't draft the ordinance, the initial FEMA ordinance. This is going to sound really critical, but if anyone would have really sat down and read that ordinance the way it was written, I don't know who wrote it, I don't know when they wrote it, but it was almost incomprehensible for any person to read, let alone someone who's trained as a lawyer. So the county commission took the opportunity of saying, while we're tweaking this to make it constitutionally correct, why don't we correct all the other problems, like the typographical errors and the grammar and things that just shouldn't be in there? or we're contrary to West Virginia law, or we're referencing a West Virginia statute that wasn't even in our books any longer, or a regulation in the Code of Regulations that isn't consistent with the current code. So I would suggest to you that we would not, as the County Commission, be doing our job if we simply tweaked it and put a couple paragraphs in to provide notice, which is the real reason that Judge Sweeney held that part of the ordinance unconstitutional. This is an opportunity to get a more perfect document that is more practical for all. And that doesn't necessarily mean there has to be these huge disputes. I mean, we've asked for public comment. There has been wonderful public comment. I would venture to say that on any ordinance in the state of West Virginia coming out of the County Commission, that this particular issue in Doddridge County has been more vetted or vented than any ordinance ever in the state of West Virginia. And that's a good thing. There have been excellent ideas brought forward by residents, landowners, surface owners, oil and gas industry, etc. And my biggest fear is that while we're all kind of centralized on the thought of oil and gas because of the pending EQT case, that there may be provisions in here that others may need to tweak that aren't present. For example, the manufactured home industry or the coal industry. And we really have done, I think, an honorable job of making this more public and trying to broadcast it to the news so that if anyone had an issue with the floodplain ordinance, that they'd be present tonight to voice it and bring it to the attention of the commission. So I would suggest to you that yes, you could, in a minimal way, tweak this, go back to a bad draft of an ordinance and tweak it to put the notice provisions in and go home. And then what would happen is, within 2 or 3 days, the County Commission would be sued by several entities, and we'd be litigating again in circuit court when we have an opportunity now to write it correctly and to have it make sense. I mean, I came tonight, I've read this thing at least 10 times, and it does take an hour and a half to 2 hours to read it. You have to read it with a ruler to read it, okay? And I came tonight with these pink tags because I sat down and I said, well, I've read this. I understand what the litigation's about. I understand the floodplain ordinance better than I've ever have. But what does this mean? And I've asked, and I went to Kevin Stan. I said, Kevin, in 4.3 and in 4.4, there's this one line that I don't understand. I don't understand why it's there. And honestly, Kevin read it and said, I don't know why it's there either. And if we don't know why it's there, then that's a problem. And Kevin has promised to go ask FEMA, well, why is this here? You know, why is it there? And so while you might think, I mean, we've been accused of being shady or being secretive or being a homer for the oil and gas industry or a homer for the surface owners or a homer for this or that, really, the County Commission is truly trying to get a more perfect document that takes care of all the concerns of citizens, all the concerns of the residents, and making things more practical even for the oil and gas industry. If they bring forward something that we have in the proposed order that just doesn't work. It doesn't make sense to put something in an ordinance that just doesn't work. So we're doing our best. I mean, I hope, I know that I can't convince everyone in a 5-minute speech that we're genuinely trying to make this better for everyone. That's what we're trying to do. And I would argue to do more than just tweaking it to satisfy the judge.
Well, again, that was the semantics. I didn't mean to get focused on that particular word. We are improving it and we are changing it. I just wanted to verify that we aren't without an ordinance. The clause or the phrase that someone used that it was declared unconstitutional, that to me implied that we don't have an ordinance. We do have one. It's flawed and we're trying to improve it. Correct?
Well, I think a fair reading of Judge Sweeney's order is that he held this one section unconstitutional because there's other reference in the order that suggests that other parts are still viable. Now, I will tell you that that could be litigated. I mean, anyone from EQT or Noble could come forward and litigate the current status. The reason we put the moratorium in is we had another driller in the floodplain who hadn't sought a permit, and we just had to stop everything because we didn't want to go through 2 or 3 situations where we hadn't given the proper people notice under the ordinance, which I think made sense. Yesterday, the county was sued again, okay, regarding this issue by JB Drilling. And so we don't have time to spend a year and have a committee to do this. I would suggest to you that that is just not workable. It will never be done. And I'll analogize this to what happens in the West Virginia legislature. Very rarely does a bill come up in one session and get passed in that session without it being heard at least 5 to 7 years before. You know, you always wonder, well, how did these legislators know what's in these bills? Do they read them all? Well, they've sat in interim meetings for years over some of this legislation that's been percolating and percolating and percolating. We are, in a relatively short period of time, dealing with a fairly large, massive ordinance that literally, if it was coming through the West Virginia legislature, it would take years to promulgate. Okay? But I would suggest to you that we don't have a lot more time because the county's going to be sued again for not having progressed it in a timely fashion so that whatever industry or whatever landowner that wants to do a development has some permit processes in place that are constitutional to move forward.
I gotta say something. We are under a time constraint. I have been asked by FEMA, and don't take this the wrong way, please. I have been asked by FEMA to devise a letter to send to the Doddridge County Commission to say, hey, you got this much time to get this ordinance passed. I was asked about 3 weeks ago to do that. You haven't got that letter yet, have you? So I haven't sent it to you, so you haven't got a time frame yet. But there is a time constraint on here. FEMA has asked me to write this and try to give a deadline because is there any permitting in the floodplain going on right now, Dan? That's what FEMA's concerned about. Since, you got a permit, there's people out there probably wanting permits, to do things. They're okay to do in the floodplain. Some things are. But there is a little time constraint here that, I've been trying to push off and give more and more time because this is a very difficult issue. But there is a time. And I want to say something else too. Talk about how difficult this ordinance was to read. Little bit irrelevant to some people. My daddy was a preacher for 10 years. And he would tell me every Sunday that, he said, there's new things in there that I didn't know about. I've been doing this for 3 years. I'm still learning about it. Okay? And yes, Mr. Kennedy pointed something out to me this morning, and I was like, wow, I never really caught that. And during the court hearings for this whole thing, there was a couple things brought up, and I thought, wow, I never really learned. So it's a very hard ordinance to understand and to do, to administer. So it takes a lot of training. There's only 6-hour mandatory training a year for floodplain managers, and it's hard to comprehend all that. Yes, ma'am.
Well, it's so hard to understand that nobody wants to read it and go through it. How do we know we're actually being protected?
That's why you've chosen your Doddridge County Commission to try to, keep you protected. The first sentence
Well,
here
but
is
I mean, how do we, I can say, yeah, I'm going to protect you, but how do you know?
Well, the first sentence here.
Nobody's going to tell it. They're just going to say you're protected, and we got to believe it.
The intent of this ordinance is to promote general health, welfare, and safety to the residents and real property owners of the county and persons who may be affected by flooding. That's the very first thing. That's